Okay, well, good afternoon again, and welcome to the second panel of the day of our live webinar series, Recognizing the Growing Economic Impact of Patent Licensing. My name is Brian Pomper. I'm the Executive Director of the Innovation Alliance, one of the co-sponsors of this series. Thanks to our other co-sponsors, the Licensing Executive Society, USA and Canada, the Licensing Executive Society International, the Global Innovation Policy Center at the US Chamber of Commerce, AUTM, and IP Watchdog. This panel is entitled The Effects of Global Licensing, and our moderator is Patrick Kilbride, Senior Vice President of the Global Innovation Policy Center at the US Chamber of Commerce, one of the sponsors of this conference. Before I turn it over to Patrick, a note to our viewers. If you have a question you would like to ask the panel, please use the chat function by clicking on the icon in the row of icons at the bottom of your screen. Take it away, Patrick.
Thank you very much, Brian. Great to be here with a really distinguished panel and part of a very important conversation that's been going on now for years, but really in a very focused way in the last few weeks, thanks to the Innovation Alliance. So really appreciate the efforts here. We have a panel today, as Brian mentioned, to talk about the effects of IP licensing, and a really terrific group of experts to help us think through the issues that are at stake and the opportunities ahead of us. But before we get into introductions, I'd like to offer a few introductory thoughts on behalf of the US Chamber of Commerce and its Global Innovation Policy Center, where we work with intellectual property creators from every sector of the US and global economy. And to help to focus some of the issues that we're going to discuss, I'd like to think about 5 things that we have done exceptionally well in the US economy and that's driven so much of our economic growth, leadership, and success over decades, if not centuries. And so what are those 5 things? It's first, we compete. You know, through a focus from the very beginning of our country on freedom of interstate commerce, we've always fostered competition. Second, we fail. We enable our businesses and individuals to take risk and recover and try again. And that failure has been a central part of our ability to foster success. Third, we respect private property. We ensure that when you put in the labor, you have the right to the fruits of that labor, as President Abraham Lincoln famously put it. Fourth, we provide rule of law. We make sure that the rules and the market infrastructure are in place to provide due process, to provide predictability, transparency, and the highest possible degree of legal certainty. And fifth, and maybe with significant importance here, we make markets. We provide the capabilities for assets to come off the sidelines, the cash to come out from under the mattress, to be allocated to those efforts that provide the most productive reward. And through these 5 things, we've driven an economy that has been the envy of the world. Now, today we find ourselves in a somewhat changed set of circumstances. And I'm not talking about COVID-19, although I will get to that. I'm talking about the emergence of the knowledge economy. And if you looked at the makeup of our economy just 30 years ago, it would have been 85% in market value vested in physical assets, plant, real estate, and equipment. About 15% would have been in intangible assets. Today, that number has been flipped on its head, and we see just roughly 15% of market value of our businesses in physical tangible assets, and fully 85 to 87% in intangible assets. That begins with our conventional intellectual property rights, the inventions that we patent, the creative works that we copyright, the brands and logos that we're able to trademark, and it extends to a much broader array of trade secrets, that proprietary information that companies have developed over time. But even beyond that, it applies to the investments that we make on the government level, on the firm level, on the individual level, in skill sets and capabilities. The money we spend to aggregate research capabilities, for instance, in the biopharmaceutical sector or the telecommunications sector, the personnel that we invest in that are so much greater than the sum of those parts. And if we're to lead in the 21st century economy, it will be because we manage to make those assets work for us in the same way that we did physical assets resources in the 20th century. IP licensing is going to be a critical piece of this. What does IP licensing do? It requires parties with different skill sets and different resources to come together, and when they collaborate on a project, they have to be able to agree on the relative value that they bring to those projects. And when they do so, then, and when the laws protect them and their rights, then they can enter into productive collaborations. That has never been more important than in today's pandemic situation, where we see collaborations coming together on the fly across borders, across sectors, to enable the race to discover treatments and vaccines that can address this COVID-19 pandemic. One of the reasons that we've been so successful in leveraging the resources that are available today is because the United States has led the establishment of strong intellectual property laws that facilitate those mutual understandings between very diverse partners. It's not enough to just do that in the biopharmaceutical space. We have to extend that to our entire economy. And when we can do so, then we'll be able to fully leverage a new form of capital for a 21st century economy, one that takes advantage of the investments that we as individuals at every level, at every component of our society are bringing to our economic activity. So to talk about some of the issues that come up in application, we have a really tremendous panel here. I'd like to introduce them very briefly, just by title and affiliation, because I think they're very well known to all of you. First, from American University, the professor and department chair of economics, Walter Park. And we have the senior fellow from the Peterson Institute of International Economics, Chad Bown. We have the section chair for antitrust and competition law and former Federal Trade Commission acting commissioner, Maureen Ohlhausen. And from the Berkeley Center for Technology and Law, the head of their Asia IP project, senior fellow and director, Mark Cohen. By way of disclaimer, Mark also works closely with the U.S. Chamber as one of the experts on our U.S.-China IP dialogue. And I want to welcome Walter, Chad, Maureen, and Mark. And I'd like to turn first to Walter to help us frame this conversation. And Walter, when we discussed this, it was in terms of the geopolitical aspects of IP licensing and some of the developmental differences. So I wanted to ask you, to what extent are there international developmental or industry differences to weigh in crafting a high-functioning global marketplace for IP assets? You know, would those necessarily call for differentiated policies regarding licensing, or can we come to some common terms of agreement as to how to approach these issues?
Well, thank you very much, Patrick, and it's a pleasure to be here and to share some ideas. And clearly, as your opening statement said, licensing is an integral integral way in which intellectual property is exploited and allowed to create value for the economy, both private value as well as social value. But yes, it is the case that when you think about the size of the licensing market, the importance of licensing and policies pertaining to licensing will vary by level of economic development as well as by industries. My remarks are largely based on my own research, which uses data from the Bureau of Economic Analysis using firm level data. So internationally, let me just point out that there are two observations. First, the kind of licensing that we see America engaging in with, say, the developing world is predominantly affiliated licensing. That is licensing between a parent and an affiliate. So a lot of intra-firm licensing, which is good. That's another way in which we transfer technologies globally. But what we'd like to see more is a rise in the share of unaffiliated arm's length licensing. And that's critical because the developing world particularly don't do as much R&D. It's still the case today as it was decades ago that most of R&D is concentrated in Europe and the US. So the developing world, instead of reinventing the wheel, what they can do is acquire, purchase, and license from the north, the developing world. And thereby, by producing, they enjoy some learning by doing. So what the critical factor there is the fact that they have weaker IP systems. And that's what causes firms to lean more towards affiliated rather than unaffiliated, rather than going outside the boundary of the firm. And the second observation that I'm noticing from the data is that, and here I have to be careful on how I define things, but overall the licensing market is still small. So there's still scope for growth. So what do I mean by small? Well, many ways to measure that. One way is just look at the licensing revenues as a share or ratio to R&D. Because after all, if you do the R&D, you either exploit the innovation yourself or you license it and indirectly profit from that. But the share of the ratio of licensing to R&D is still small. And also another way in which you can measure the smallness is relative to other ways in which you transfer technology, exporting, and doing foreign direct investment. Again, licensing tends to be small. So it could be that there is a latent demand for licensing. It could be that institutions need to be changed in order to allow for more of this activity. But it could also be that that some firms might choose to, keep things a trade secret, not want to, license to others. It could be that generally, whether you do everything internal, in-house, or engage arm's length depends on transactions costs. So you had Karsten, I think, earlier in your week, and he mentioned that point, and I would echo that and point out that if transactions costs of dealing with your suppliers is too high, you generally tend to do everything in-house. But if the lower the transactions costs can become, the more firms can engage in outward licensing. And that's where I think institutions and IP matter. And in particular, that's where also the industry differences lie, in that the transactions costs really vary by industry, as well as the nature of technologies. Some technologies are modular and more amenable to licensing, others are not. So, I'll just point out, for example, that you observe far more licensing in the complex industries, like electronics, and relatively less in pharmaceuticals, although it's, so those, I think that when we're shaping IP policy, one has to take into account variations in the market sizes between developed and developing countries, and differences in industry, and not necessarily look for common standards, because you want to allow for the fact that perhaps different industries have settled into their own natural equilibrium. So with that, I'll pass on to others.
Thanks, Walter. So, you talked a little bit about some disincentives to reaching our goal of more unaffiliated licensing. And I'd like to, turn to Chad with the Peterson Institute there's China is obviously, and the U.S.-China relationship is such a heavy focus these days of conversation among all of us, and so significant for global trade in all forms, let alone trade in intellectual property assets. But can you comment on, so how does this U.S.-China trade war, and maybe specifically the U.S.-China tech war, relate to this IP licensing question? And for instance, U.S. actions on export controls, is that a stimulus to changes in the way that China has approached, IP, or is it going to, further drive some divides?
So, great questions. Thank you for the opportunity to be part of the panel. And just to warn everybody, I'm a trade economist. I'm not an IP lawyer, and I'm also not really even an IP economist. So I've very much been thinking about a lot of these issues in the context of the U.S.-China trade war and the disruption, I guess, that we have seen come out of that for the last 2 or 3 years. I think it's important maybe to walk us through, the various stages of this, because I think all of them are related to this issue that the panel is really touching on today. So in many respects, if you go back to not necessarily what the point of President Trump's trade war was, but what the Section 301 report was all about, was about technology and forced technology transfer, and American companies in particular not being happy with their way their IP was being respected, protected in China. And so that was a big part of what kicked things off. We go through this trade war. The United States puts lots and lots of tariffs on, especially on products coming in from China that are inputs as part of these global supply chains, which may in and of themselves feedback and affect, these high-tech industries and, the idea of remuneration and licensing and how folks are getting paid. So you have those kind of elements early on. You've got ultimately an agreement, this phase 1 agreement, that's got elements in it of China changing its domestic laws to improve upon some of this. I won't speak in too much detail about that. I'll leave it for some of my other panelists to be able to speak to what China is doing in that space. But there is some element of perhaps progress in that area. But then at the same time, this year and beginning last year, you're seeing these export controls really affecting the high-tech space and this issue of licensing. So beginning in 2019 with the addition of Huawei to the entity list, and again, Huawei is a major Chinese consumer of American high-tech products and licensed products. By being added to the entity list, at least in the past, that meant American companies could no longer sell their semiconductors, their IP, their software, whatever, to Huawei. Now, there have been changes with the Trump administration and the allowance for some exceptions. It's unclear if this is going to continue on a long-term basis or if these are just one-off temporary items to allow transitions to take place, maybe to allow some of this remuneration on past purchases, past agreements for continuing to go through. But it does raise a lot of questions, right? We had the export controls on semiconductors and kind of the EDA folks in 2019. And in this year, them being extended through this thing called the Foreign Direct Product Rule, because a lot of the American IP firms in the semiconductor space in particular have their manufacturing done overseas. It was unclear whether or not these export controls would ultimately sufficiently apply, whether they would bite enough on, say a semiconductor being manufactured in Taiwan at a fab there, or the fact that you have major competitors to American high-tech industries like Samsung in South Korea or other firms in Asia not being subject to these export controls. So, the administration extended the reach of U.S. export controls by targeting a different industry, the semiconductor manufacturing equipment industry, and essentially telling these foreign firms that if you want to continue to sell to some of these Chinese firms, Huawei in particular, you can no longer use American equipment, or that's effectively telling American companies, you can no longer sell to some of those guys, right? Because these industries are so IP intensive and are so wrapped up in this licensing, sort of world, I think this has very, very big implications for how to begin to think about this now, how this is going to affect the writing of contracts. If it's likely or increasingly likely that in ways that it hasn't been in the past, that government policymakers are suddenly going to be able to step in and disrupt, what had been long-term relationships where, the expectation of future access to my IP meant that you would pay me licensing fees off into the future. Maybe those contracts are not the right way to design things up front now. So I think the way the trade war has been conducted, especially in the high-tech space, has played out so far, is probably led to substantial disruption in this particular area. Now, I, as a non-expert in the area, I'm just kind of thinking through the economic incentives. I'd be curious to hear from the others, is that what you're seeing on the ground? My sense from the industry folks that I talk to is definitely yes. But, as an economist, I'm not fully convinced until I can actually see it in all the data. So I look forward to hearing at least some other anecdotes coming in from the other panelists on these points.
Yeah, thanks, Chad. To that point, I think what we're seeing today and what you described is really a more overt and aggressive sort of tech war, as you put it. But arguably, there's been a cold tech war going on, or a cold IP war going on for some time. And Maureen, one of the tools that we've seen governments resort to, and certainly industries, both here in the United States and around the world, pressing, is use of antitrust to evade, essentially the market requirement to license IP. Can you speak, Maureen, to how that's played out? What does it look like to use antitrust as a tool to police the rights of IP holders, maybe especially in the licensing of standard essential patents? And what's the latest with those attempts, whether in the courts, the US DOJ, and what does that portend for these arguments in the global markets?
Thank you, Patrick. I'm happy to talk about that. So antitrust law, I think people often conceptualize it as it's supposed to prevent monopolies. And then it creates this tension with the idea that, well, intellectual property is essentially creating, the ability to have a monopoly. It doesn't necessarily confer it. The Supreme Court has said that, but certainly if you have an IP right, the ability to exclude others is the core part of that. So the question becomes, how do you reconcile those two things? And for the most part, there has been an understanding that if you have an IP right, you are able to assert it against others. So I think for that, putting it into the way Walter was talking about it, it's fairly well accepted that, if you have invented a product and you make the product, then you can sell the product and you can stop others from copying it and in violation of your patent or your IP. It gets a lot more complicated when we're talking about highly complex technological products, where what you end up having is a standard setting organization where the creators of the IP, they can focus on the R&D, the invention of it, and then they put it into a standard that then the implementers who aren't doing the R&D, who just want to manufacture it, are in that standard setting organization too. And there are agreements made about what the standard setting organization, which IP it will adopt for the standard, and then how this IP holder will license it to the implementers. So that's the idea of what we call standard essential patents, right? A patent that you have to have access to practice the standard. And these standard setting organizations typically require licensing on fair, reasonable, and non-discriminatory terms. So antitrust has gotten involved now with the idea of, well, what if there is a disagreement between the IP holder, the holder of the standard essential patent, and the entity that wants to manufacture for that. And one of the things that we had seen in the previous administration, the Obama administration, they started to have concerns about the idea that the holder of the IP could engage in what they called hold up for the implementers and get a higher than competitive rate for their IP because the implementer has invested in creating its product to meet this standard. So somehow the IP holder could say, you know, now you have to pay me so much more than you expected because you have these sunk costs. And so they took a number of actions that reduced the ability of the IP holder to assert that right. They said, concerns that if you go to get an injunction, right? So typically if you have a patent and someone is violating it, you can go to court and you can get an injunction. And then, the Supreme Court came up with the eBay case, which said, well, an injunction may be harder to get because if it can be cured with money, you can go forward with that. You won't stop them from, manufacturing or bringing in the product. But the FTC brought some actions where it was saying, no, simply asserting and trying to get an injunction is itself a violation. So what happened was in the new administration, the Department of Justice thought that this playing field had been tilted too much against the IP holders. And Macon Delrahim, who's the head of the Antitrust Division, issued what he called the new Madison approach, where he basically emphasized that the IP holder has a right to enforce its IP, and that essentially the violation of a commitment to a standard setting organization is mainly a contractual violation or contractual dispute and not an antitrust violation. And so the DOJ has intervened or provided amicus briefs, business review letters, things like that in what in their view is to rebalance the scales here. So interestingly, at the end of the Obama administration, the FTC, when I was a member, brought a case against Qualcomm, arguing that Qualcomm's assertion of its IP right for its licenses was an antitrust violation. I objected, and particularly because I thought there wasn't a sufficient amount of evidence, and also because of my concerns about the signal that this was sending around the world. That the idea that an IP holder will be forced to license to others, even who are violating, or, not paying the agreed upon license fee, seemed to me to encourage some of the trends we were seeing to use antitrust to require, essentially, forced licensing of technology, then on terms that the regime would decide were fair, right? So I had big concerns about that. The FTC proceeded with that case. They litigated it in the district court, and the district court found a broad obligation for an IP holder to license, not to be able to decide which licensing terms were the most advantageous to it, to say it had to license to others, and to also give a worldwide remedy, antitrust remedy, for violations. So the Ninth Circuit just recently overturned that decision unanimously and knocked down the idea that there's just broad obligation to license, that there's something wrong with trying to come up with a licensing regime that is most advantageous to the IP holder. And so that was a very, very important decision, and I think got rid of the worldwide remedy. So I think some of the rebalancing seems to be taking hold in the courts, and just to mention some of the previous efforts that the FTC and DOJ were doing then were really more in the realm of policy decisions or settlements or things like that. But really, when these theories got to court, they don't seem to be receiving a very warm reception. So it'll be interesting. I'll mention one other case, Continental Automotive Systems versus Avanci, and that just came out, and again found that just merely breaking a FRAND promise or a dispute on a FRAND promise didn't translate into an antitrust violation.
Yeah, thanks, Maureen. I think, to this point, we've heard from several of you, one that IP licensing is a really important function within our economy to enable technology transfer, whether between, as Walter described, a parent corporation and its foreign subsidiary, or, as we might like to see more of, unaffiliated technology transfer, and yet, and how important that is to today's economy that is really driven by intellectual property creation, and yet we see constantly new obstacles being thrown up to market-based IP licensing, whether it's sort of the export controls when we get these trade wars, or it's use of antitrust tools to limit the rights of IP holders, and in my view, diminish their incentive or their willingness to commit resources for the long term. I think that sort of takes us to, what are the stakes? If we can't overcome these problems and enable more functioning markets for intellectual property, what are we going to lose? And I invite any of the panelists, Walter or Chad, you might have some views here. And then I want to turn to Mark about, what the opportunities are to really address this challenge and take advantage of the opportunities that we have from a much broader and well-functioning IP licensing market. Would anybody like to jump in on the stakes?
I'll give an attempt. As an academic, I don't, get involved in the corporate, issues. What Maureen talked about, I only just read about, Qualcomm and its dealings with FTC or complaints about royalty fees being too high and so forth. And recently, it's not related to licensing, but again, you hear these things like Apple is having a conflict with Epic Games. They produce for Fortnite just because they have the app store platform, and they didn't like the fact that Epic Games went somewhere else to sell their product. So, firms will always combat with one another. So that's the case. So the other side of the stakes would be the consumers, the society as a whole. We benefit from competition, and what Maureen's discussed is important. That we want to make sure that the licensing market, even if it's wrongly viewed, but we want to maintain, fairness, equity, and competition. But ironically, interestingly, in the economics literature, we often see licensing as a means of making a market more competitive. So a long time ago, Kenneth Arrow did a famous analysis, which is better, more conducive to innovation, a monopoly or competition. And even though, we know that patents don't create monopolies per se, right? It's a piece of technology. It's very rare for patents to create a monopoly. But that's said in a very simple framework. In the end, Arrow concluded that competition does more to incentivize innovation. And the structure was basically almost like a non-practicing entity. Basically, you innovate, you can either choose to be a monopolist or license it non-exclusively to everyone. And then you don't have to manufacture, you can just license it. And the rewards of doing that, just collecting royalties, gives you greater profits than being a monopolist. That was the point. And so in terms of your question about stakes, I look at it also collectively, that social welfare is measured not only in terms of the profits of businesses, but also the gains to consumers.
Yeah, thank you, Walter. And Mark Cohen, turning to you, so, okay, let's accept that we really don't have functioning markets for IP licensing today, for all the reasons that have been described. And arguably, better functioning markets would enable more organic tech transfer, the kind of unaffiliated licensing that Walter described. What are the opportunities? What are the tools that we have, the vehicles that we have to improve this situation? And what are you focused on in your work?
Okay, well, thank you, Patrick, and thanks to everybody else on this great panel. It's a pleasure to be with all of you. Actually, I'm going to try to tee off a little bit on some of the comments from others in responding to your questions. I was very happy to hear Walter talk about how he looks at unaffiliated licensing versus affiliated licensing transactions, because it's something that I've observed in recent years with respect to China, where in recent years there's been a shift from licensing that was largely to parent subsidiary affiliated transactions of the type that Walter's mentioned. And beginning about a year or so before the trade war around 2017, it flipped and it became 60% unaffiliated and 40% affiliated. And I took that exactly in the way that Walter suggested, which is that there's something happening in the legal system, or perhaps other economic motivations, that's encouraging the kind of merchant licensing transactions that are the sign of some healthy signal within the Chinese economy. It's unlike Taiwan, where Taiwan has a predominant unaffiliated licensing environment, largely because of the design work that's done outside of Taiwan for manufacturing within Taiwan. So they've developed a whole licensing-driven model for the semiconductor sector. This is really important, though, and it's really a counter narrative, if you will, to the 301 narrative, which is that China has been reforming its IP regime. It is a tremendously under-licensed environment. And Maureen, I recall twice, I believe, testifying with you, where I brought this up. You can't have IP abuse, antitrust violations, in my view, unless you have IP use. And for most IP holders in China, it still remains an under-licensed environment, whether that's due to infringement, theft, forced technology transfer, what have you. We can speculate. But China has today about a third of the world's high-tech production, and it's, as a rough comparison, it's responsible for about 4% of royalty payments that the US receives. That gap, however you want to compare it, is what you might call an infringement gap or the like. So this trend towards unaffiliated licensing is really good. The other thing that happened that was also really significant is, as a result of the trade war, this is getting a little bit to Chad's comments, you had a change in China's licensing law, its regulations, called the Administration of Technology Import-Export Regulations. I'd like to drop off the A and just call it the tier. And the tier imposed some onerous requirements on foreign licensors, not on domestic licensing transactions, which really probably helped drive this affiliated transaction environment. Basically, the tier required a foreign licensor to indemnify the licensee against any third-party risk. It mandated that the licensee owned all improvements, and it mandated that the licensee had access to reasonable markets, typically overseas markets. This was not the situation with respect to a domestic transaction or an export transaction, and it probably drove some distortions in licensing arrangements by foreign companies who would typically license to an affiliate that might sub-license perhaps within the Chinese market. That's gone away. Unfortunately, it took 20 years for this onerous regulation to be revised. There's still a pending WTO case around it. And it's happened at a time when markets are being disrupted due to tariffs, sanctions imposed by the Trump administration, or counter retaliation due to the kind of export controls and CFIUS controls that Pat briefly spoke about, and due to other changes like Hong Kong losing its special trading status on the COVID-19 crisis. So, and the availability of PPE and diagnostics. So unfortunately, I don't know if China's going to reap the full benefits of that liberalized regime. But there may be an opportunity here for the global trading system to benefit. And if you're going to, at the risk of sounding perhaps hopelessly optimistic, I want to just say a few things about the potential impact here. And the data is too early to really judge that impact, although there is some anecdotal information, and hopefully I can talk about that. We've looked at, and Phil Rogers, my colleague from Berkeley, who's actually listening in, we have some papers coming out on this topic. We looked at research done on global extended supply chains, so particularly Dr. Athukarala, who's written on this topic, and identified products that are made over extended supply chains. And the really interesting thing about these products, so this may sound intuitive to many of us, but nonetheless worth restating, is that if you looked at the tariff classifications of goods manufactured by IP-intensive industries, as identified by the PTO, or the European Patent Office, or the Chinese Patent Office, who have all done 3 studies in this area, the correspondence between IP-intensive industries and their exports and supply chain intensive products, extended supply chain products, is roughly 82%. That is, most of the products made over extended supply chains are IP, particularly patent intensive. That's using the USPTO number. It drops a little bit with the European and Chinese numbers. So, but I like the USPTO number at 82%. So you have this phenomenon that supply chains are being interrupted for products that tend to be IP intensive. And what are those products? It's medical diagnostics. It's the kind of IT products that have been the subject of antitrust cases, Qualcomm and others. It's scientific instrumentation, automobiles. And who are the countries making these products? China has about 1/3 of that global production. And Mexico is probably the only major country, manufacturing country, that comes close in participating in those supply chain products. And other countries like Vietnam, India, Philippines, Indonesia, Taiwan as well, have capacity and trying to ramp up. So what happens if the supply chains do get disrupted? Well, first of all, no country, with the possible exception of Mexico, in the developing world, has the scale of China. So this is a hard beast to fully disrupt. And I think we have to be reasonable in our thought about that. Also, China has a huge market. So even if a company wants to have a more resilient, diverse supply chain, they may say, I'm going to leave my manufacturing in China. And that's in fact what business surveys tend to say. 2, 3, maybe 4% of American companies in China say, I'm not moving. But the CEOs, their headquarters, are saying, you know what? We need to think about alternative supplies. Now, if these are going to be, this is going to be manufacturing in other markets, the US, not such a problem. TSMC can come over here, great infrastructure, great IP regime. They can enforce their patents. In fact, they're a major patent holder, and they're talking about building a fab in Arizona. But what happens when it's India or Vietnam? Well, those countries, first of all, have really small patent offices. India, medium-sized, with about 30,000 applications per year, compared to 1.6 million in China and about, 700,000, 800,000 in the US. So you're dealing with IP-intensive products without the IP-intensive infrastructure, to put it broadly. So the opportunity here is, if those supply chains are going to migrate, we all have to find a way. If it's not going to be migrating back to the developed world, if some of these products still are more advantageously produced in economies like Vietnam and India, which have developed policies to encourage this. And Samsung, for example, has said, I'm moving to India. And some of the Taiwanese manufacturers moving back to Taiwan, et cetera. So we are seeing a lot of this anecdotally. There's also going to have to be some kind of virtuous cycle to support the infrastructure where you could license in, see your IP rights protected, and have the soft legal infrastructure to support it. We're seeing a little bit of that. The data, as I think Professor Park would also agree, is still too early to have some comprehensive assessments. We're seeing this certainly in technology transfer on the Chinese side, and to a certain extent on the US side, where we've had collaborative projects like RISC-V for semiconductors move out of the US to Switzerland because of the overhang of US controls over standardization semiconductor technology.
Yeah. Mark,
yeah.
let me stop you there for just a second, because I think you're on a really, are you wrapping up? Go ahead.
No, I'm just saying, and then some open source projects where we also see some collaborative development going on, often with Chinese participation. Still a little bit too early, but I'm optimistic that if supply chains are interrupted, and even if a little piece of China is bitten off, this could have a dramatic impact on the developing world, and we need to support it.
Thank you. I wanted to stop you because I think you're on such an important point. I want to draw in the other panelists a little bit here. Let's for a second, be fairly presumptuous and put ourselves in the shoes of, a leader in Indonesia or India or Vietnam, and you see a window of opportunity here. You say, I want to be a bigger part of global supply chains, especially in these sophisticated value-added sectors, and we've done the assembly pieces, to an extent. But you want to communicate to some of the leading innovators in the world, whether they're US-based or Europe or Japan or where have you, in China. What do you say to them? How do you market your country and the things that you would be willing to do to foster the organic technology transfer, the unaffiliated technology transfer that would really let you be part of these supply chains? Speak for a second to that global innovative company and tell them what they want to hear. Mark, I could go to you, or if any of the others want to jump in on that question, I encourage it.
Well, I think there's a little bit, I've thought about this question, Patrick, and I think there's a little bit of what I think I would tell an official in Vietnam or India is not to imitate China. And I think what we've seen with China is a nice infrastructure put up front, a developing IP regime and courts, et cetera. But then this underhanded aspect that's concerned about economic espionage, China's treatment of foreign patents, IP theft, what have you. And I think countries like India, Mexico, and others perhaps, if they put the right welcoming infrastructure in place and it's perceived to be transparent and available, that by itself is a rather limited cost for a big benefit in terms of attracting investment. We already see a lot of these economies putting up tax policies, tariff preferences, free trade zones. That's great. That may be a major factor along with the size of the market. But the soft infrastructure, I think, is really critical as well.
Let me put the same question in maybe a more focused way to Maureen, because I think this antitrust and using competition policy as a tool against innovators is such a threat to licensing. Maureen, you're a competition policy regulator official in a foreign market that wants to attract more tech transfer, wants to be part of these supply chains. What do you say to the company that's invested decades in developing a particular technology about how you're going to approach antitrust, that they say, okay, that makes sense to me. This is a market where, if presuming that this policy is consistent, that I can do business?
So I'd say two things. Certainly, antitrust law, to the extent that it protects against mergers to monopoly, cartel behavior. You want to have all those strong protections in place. But the other thing that I think has been a temptation for some of these countries that are not they're not the IP holders, they're the, they're the, the manufacturers, is to come up with this idea of the essential facilities doctrine. So, I've been in China and, heard it argued like, we want competition, and you say, competition is what we should be striving for, but, you have to have competitors to have competition, and to have competitors, to compete in this market, you need this technology. So the holder of the technology is going to be forced to license it. And well, gee, we have a fairness requirement too, and we think it's unfair that if they're charging too much for it, so you can twist these antitrust and unfair competition terms into something that I think makes it, not just unattractive for foreign investment, but I think one of the most important things to keep in mind also is what creates that R&D, that innovative, ecosystem in your own country. And one of the things that I did was you can't necessarily show causation, but you can show correlation between the strength of IP law and the investment in R&D in a company. And I actually did a big study looking at this, trying to find all the evidence that I could find. So when you put together an antitrust regime that doesn't essentially force technology transfer at a government-approved price, particularly when you have government-owned enterprises, they're saying that this is too high, so therefore it's unfair, so therefore, it's an antitrust violation. I think so. You put together a strong patent system, strong infrastructure, and an antitrust system that doesn't engage in this kind of, forced transfer for, purposes of fairness, then I think you can have both a good environment for foreign investment and a good environment for domestic innovation as well.
Thanks. And turning, if I could go to Chad and Walter, from that sort of economic perspective that you represent, if you're setting out to facilitate a market for IP licensing, what are you recommending? Not to any individual country, but sort of speaking to the global system. What would you like to see emerging that would help to make that functioning market a reality?
Can I just briefly start? As Marina and Mark were talking, I just thought of two things in relation to your question. I'll briefly say that some countries are eager to get into the high value part of the supply chain, and maybe they're not yet ready. And so, you see all these policies like forced tech transfer, they all want to eagerly get on this and that. And we've already seen episodes of like infant industry protection in the past, and they've backfired. And so I would just say, if possible, begin with what you're good at. And in the developing world, it's largely still agriculture. So there's still a lot of innovation they can do in seeds and food and stuff like that. And then they also have their comparative advantage in labor, wage costs. So still exploit that. And that said, my other point is, how can they participate in higher value part of the supply chain? Taking coffee, for example, or cocoa. Many people in the developing world don't even know where their raw material ends up. I mean, I saw some documentary where a cocoa farmer or grower didn't even taste chocolate before, right? And then I've been to Africa too, where a lot of their mines produce the pieces, the raw materials needed for our computers and smartphones, and so it would be. I don't have the answer, but I'm saying that right now it could be that their comparative advantage is that they have the raw materials, but they're not in that higher value part of the supply chain. And so whether IP is the critical ingredient to get that growing, it's a possibility. But yeah.
I guess what I would add to this is, even when we look at the Chinese experience, there were costs to the approach that they took, right? Some firms were just not willing to deploy their latest and greatest technologies with China because they were worried about forced tech transfer. And so this ultimately did impose some costs on China. We have some kind of economic research to back this up. And this is for a country with a massively, in some sense, environment created to be able to handle a lot of other aspects that a lot of other, especially developing countries, don't have. And then there's just also the sheer argument of China's size, and nobody else is like that, with the exception of potentially India, but India is also special, right? So if you're a smaller developing country, an emerging market, and you don't have 1.4 billion people to leverage, or the amazing infrastructure that China has been able to roll out, or the coordination of all of these other policies, then I don't think you're necessarily going to be able to get away with some of the challenging aspects that firms have felt in the IP space that China has engaged in. And so I think I would agree with Walter that it's very much, kind of create a general environment, but then be supportive of where it is that, you have your own strengths, and don't overreach, especially in the IP space, because it could just be that firms decide that it's just too risky to engage their activities in your market at all, and that can be very, very costly.
Thanks. I'd like to sort of finish where I started with the suggestion that there's a real benefit to all of us in the U.S. in terms of our competitiveness and global leadership, to the world in terms of levels of innovation and opportunities for growth, in making sure that we continue to allocate resources to innovation and creativity. And, I think we find in any aspect of the economy that the easiest thing to do is to take your money and put it under the mattress. If you got it with you, it's safe, even if you're losing some to inflation. And the job of our economic governance is to encourage people to get their money out there in the market so that it can be leveraged. We've done a good job of that on the physical economy. We've really not yet done it well on the intangible side of the economy. The country that gets it right is going to be in a real, is going to have the pole position, the leader position, being able to drive global growth and competitiveness in the next economy. In my view, I like to just throw that back at the panelists. Lightning round, no more than 30 seconds each. Give us your critical thought about IP licensing. What is the one key point that you want to make sure this audience is left with? And Chad, since you're on, let's go to you first.
I would say you're right, but I think things are going to get worse before they get better. I think the disruption that we're seeing with China means a lot of firms that have been able to have access to the Chinese market are going to see that cut off. I think we're going to see this in the semiconductor space. That means a decline in revenues. That means a decline in funding they have available for R&D. And innovation is going to slow down. We're already seeing, requests for new subsidies in the United States for the industry. So I think this is really a period of disruption before we see, sort of get back to nirvana as you're proposing.
Well, thank you. Walter, next to you.
I would just say that, licensing is, my earlier comment was it's integral, and I mean that it's there. You can't escape it. Earlier, people have been talking about an ecosystem, a knowledge innovation ecosystem, and like it or not, you can't do everything on your own. As an inventor, you stand on the shoulders of others, and if what you're standing on happens to still not be in public domain yet, then you have to pay for it. You have to create some kind of arrangement to utilize it, and as an inventor, you also have other contemporaneous inventors, and they have some piece of technology you need. You have something they need. You have to cross license. So licensing is here to stay, and despite all the disruptions, well, we have to figure out how to make the system work. And that's why
you can't do it all on your own. I think that's a great takeaway for us. And although we're over time, I want to give Maureen and Mark 30 seconds each. Final thought. Maureen, we'll go to you first.
Sure, I agree with what everyone has said, so I'm just going to take this opportunity to answer one of the questions that got sent in, which was how would the use of antitrust law have an impact on holdout activities by implementers? And I think the only way it would is if there was collective action by these implementers, like, coordinated action to all get together and say, we're not going to pay. And there have been allegations that has happened, and it has passed the motion to dismiss stage. But otherwise, it should just be treated as a contract law violation. And then you should be able to have the tools that you would have in any litigation, such as trying to get an injunction from somebody using your product if they're not willing to pay the license fee for it.
Terrific, and thanks for picking up on that, Maureen. We had another great question about how one controls processes in some jurisdictions with loose IP protection so that they can limit risks. But Mark, I won't impose that on you, but if you want to capture that in a last point, you're very welcome.
I'll try to wrap it up all in one in 30 seconds. First of all, I share, I think, Chad's pessimism about the continuing disruptions that are going on that are going to make life more difficult, I think, for companies. I also think that the optimism that's implicit in what Professor Park and others have said, including Maureen, that in fact the legal environment is both necessary and in some respects getting better. But I don't think it's all bad. As for that question raised about how you control IP risk, it's the same way companies were doing it in China, more or less, which was typically not transferring current generation technology with the hope, which I think was not always realized, that China won't catch up. And of course, keeping the crown jewels back home. This is not robust technology transfer. This is limited tech transfer because you need to exploit the market. And I think companies will continue to do that. I think China's former technology transfer regime was really not a licensing regime. It was a make a competitor regime. And that kind of make a competitor regime has severe limitations, mostly because companies are going to be very cautious about what they transfer in that environment. And hopefully others will learn from that.
Well, thanks. We didn't get into an issue that I think is really central here, but fortunately there are other panels in this conference. And I want to throw this at them: trust and rule of law. And of course they go hand in hand. So as we think about a functioning global market for trade in intellectual assets, knowledge assets, we need trust, we need rule of law. But this panel has contributed tremendously to the conversation. I want to thank all of you, Chad, Maureen, Mark, Walter, especially Brian and the Innovation Alliance for setting this up. I really appreciate your time, really appreciate your insights, and especially as well to the online audience. Thank you for taking part in this important conversation. And the U.S. Chamber is always at your service if we can be of assistance. Thanks again, Brian, and back to you.
Patrick, thanks so much. Thanks to the panelists for yet another great panel and a great discussion. For those of you viewing, I hope you will join us again next Tuesday, September 29th at 1 p.m. Eastern for our last panel in this series, entitled Increasing the Visibility of Licensing Economic Impact and Addressing the Challenges in Cross-Border Licensing. I expect that panel will try to tie together much of what has been discussed today and on the prior panels. Until then, stay safe and well. Thank you.